All right, welcome to The Explainer. Today, we are diving headfirst into a world filled with deadlines, legal documents, and court orders. We're going to navigate the super complex and honestly pretty confusing legal maze of residential evictions. It's a process that affects millions of people, but it's also one that's hugely misunderstood.
So here's the game plan for today. We're going to break this whole thing down into 6 key stages. We'll start at, the starting line. Then we'll cover the first big turn, the notice. After that, we hit a fork in the road with the lawsuit. Then, the end of the maze, the verdict. We'll also dig into the rights and defenses you need to know about, and finally wrap up with why this whole maze even matters.
Okay, first things first. The number one rule of this maze, an eviction is not just a landlord saying, hey, you need to leave. Nope, it is a full-blown, formal, legal showdown. And the law is absolutely crystal clear on this. If you're going to remove someone from their home, it has to follow a very strict, court-supervised procedure. No shortcuts. And this whole process has an official, kind of fancy name, an unlawful detainer. Now, this is the only legal way a landlord can get their property back if a tenant won't leave after they're supposed to. Think of it like the starting pistol for the entire race through the court system.
So you might be thinking, why all the fuss? Why can't a landlord just change the locks or shut off the power? And that is a great question. The answer really gets to the core of why this is a legal maze and not just a simple argument. Look, a landlord might be incredibly frustrated, but taking matters into their own hands, that's a huge, huge legal mistake.
And this right here is the absolute heart of it. Landlords are completely forbidden from using what the law calls self-help. That means absolutely no changing the locks, no turning off the water or electricity, and definitely no tossing someone's stuff out on the curb. If a landlord tries to bypass the courts, they could end up paying some serious financial penalties.
All right, let's make our first turn in this maze. This is a critical one, the formal notice. This piece of paper is what sets the entire process in motion. You can think of it as the key that unlocks the courthouse door. And get this, if that key is flawed in any way, the whole case can get tossed out before it even starts.
Seriously, this notice is the foundation of the entire eviction case. For the landlord, it has to be absolutely perfect. It needs to state the exact reason for the eviction, and if it's about rent, the precise amount owed. And for the tenant, it's a critical deadline, one you absolutely cannot ignore.
Now, not all notices are the same. The reason for the eviction determines the type of notice. Is it about unpaid rent? Well, that usually triggers a super short 3-day notice to pay or quit. But what if the landlord just wants to end a month-to-month lease? That's different. That's going to require a much longer warning, like 30 or even 60 days. The point is, the notice has to match the situation perfectly.
And it's not just about what the notice says, but how it's delivered. The law is so specific about this. You can't just shoot off a text or an email. Nope, it has to be done through what's called personal service, handing it directly to them, or substituted service. And if that doesn't work, as a last resort, you can post it on the door and mail a copy. Making a wrong turn here? It can send a landlord right back to square one.
So, what happens if the tenant gets the notice but doesn't pay up or move out? Well, now the landlord's only legal option is to file that formal lawsuit. And this is the fork in the road, the point of no return. This is where the maze gets really, really serious. And once that lawsuit is filed, a clock starts ticking, and it ticks incredibly fast. Eviction cases actually get priority in the court system. The tenant has just 5 business days, that's it, 1 week, to file a legal response. If you miss that deadline, the case can be over before it's even really begun.
Okay, so at this point, the path splits in two, and the most common route by far is this one. The tenant doesn't file a formal response. Maybe they don't know how to, or they feel like they don't have a defense, or maybe they just missed the deadline.
And in that scenario, the landlord can basically win by forfeit. They go to the court and ask for something called a default judgment. This just means the court grants them possession of the property because, legally speaking, the tenant never showed up to fight.
But what if the tenant does respond? What if they fight back? Well, that takes us down the second path. The tenant files a formal answer with the court. Now the case is officially contested, and it's headed for a trial where both sides get to present their arguments to a judge.
So whether it's a win by default or after a full-blown trial, the maze eventually leads to one place, a final judgment from the court. This is it, the official decision that says who has the legal right to the property.
Of course, this whole legal process isn't free. It definitely comes with a price tag. Even a simple, uncontested eviction has costs. Just look at these sample fees from Florida. You've got court filing fees, sheriff service fees. It all adds up. And that's before you even think about hiring a lawyer.
So if the landlord wins, the court clerk issues this final, very powerful document. It's called a writ of possession. And let me be clear, this is not a suggestion. It is a direct order to law enforcement to enforce the judge's ruling. It's the final key that gives the landlord the property back.
And this right here is the final exit from the maze. Once that writ is issued, the sheriff's department will post one last notice on the tenant's door, usually giving them 24 hours to leave. If they're still there after that, the sheriff comes back and physically removes anyone left on the property. That's how legal possession is restored to the landlord.
But navigating this maze isn't just about following steps A, B, and C. It's also about understanding the rules of the road. The law actually provides some pretty significant rights and potential defenses to both sides. It turns what seems like a simple path into more of a strategic game of chess.
And you can really see here how the law tries to strike a balance. It's totally a two-way street. Landlords have an obligation to provide a safe, habitable home and to follow all the rules. On the flip side, tenants have the right to live in that home and to defend themselves if they think the eviction is improper or illegal or even retaliatory.
And when a tenant fights back, they can use some powerful legal defenses. They can argue that the notice was messed up or that the landlord failed to keep the property in good shape. That's a big one. They can even claim the eviction is retaliation because they reported a problem. A simple slip-up by the landlord can suddenly become a really strong defense for the tenant.
So, we've journeyed all the way through this complex maze. What's the big takeaway here? I mean, why does the law make this whole thing so complicated? Why not just let a landlord kick someone out if they want to? Well, the most crucial point is this. Removing someone from their home is a really profound action. It has serious, life-altering consequences. And that's exactly why the law replaces that raw, self-help idea with a formal, structured, and impartial process. It's designed to make sure the whole thing is resolved based on legal rights and facts, not just on who has more power or who's more frustrated.
And that brings us to one final big question. This legal maze, it has clear rules, right? It has defined paths. But does it always lead to a truly just destination for both the person who owns the property and the person who calls it home? Well, that's a question that remains the subject of some really intense ongoing debate.